So with that, we'll call the first case, People versus Bruce and Nicholson.
Good morning, Your Honors, and may it please the Court. Chris Allen, Assistant Attorney General, on behalf of the people. Sitting at council table with me is Deputy Solicitor General Eric Restucia. I'd like to reserve 3 minutes of my time. Defendants Bruce and Nicholson had the statutory authority to petition Michigan courts for search warrants and arrest warrants. They could execute those warrants under color of state law. They could pull you over for speeding and drunk driving. The legislature also granted these defendants all of the privileges and immunities of state law enforcement officers. But defendants argue that despite this entrustment of these weighty duties, despite being clothed in the privileges and immunities, they should not bear the related burden of holding their conduct to a higher standard and contend they should be exempt from the crime punishing misconduct committed in the course of their duties. There is a unique harm to the state where an officer charged with enforcing its laws uses that opportunity to subvert them. And these defendants should be subject to the same set of rules and laws that their state and local counterparts are. This court should hold that these state-authorized officers are public officers when they participate as ongoing members in a joint task force primarily enforcing Michigan law. The legislature granted the defendants, by plain statute, these important and extensive authorities, privileges, and immunities in MCL 764.15d when they were acting as part of an MSP-led task force. This statute and really two cases from this court I think should guide the decision here. First, People versus Friedland emphasized repeatedly that it is the substance of the right, authority, and duty that is delegated by the legislature that controls, and not necessarily the title of the individual. Second, People versus Cotu is the unanimous 1999 decision that really surveyed the history of Michigan law in this area and concluded quite plainly that this state has historically found law enforcement officers to hold public office. At this point, I would welcome any questions from the bench.
What statute creates the position on the task force that the Border Patrol agent apparently was operating under?
It's MCL 764.15d.
Can you be, what part of that statute creates this position on this task force?
Well, it's sort of the statute in its entirety, Your Honor. It doesn't create a named, titled position, but what it does is it delegates, it authorizes these officers, so long as they meet certain criteria, to enforce state law as state or local officers do, and provides them with the privileges and immunities of state and local officers. So while I would admit there's no title of deputy so-and-so, that really is not the question. There was a creation here by the legislature in 1999 of a position, a state-authorized officer, to act as any state or local officer otherwise could.
I mean, the statute clearly gives them the authority to act and enforce the laws of Michigan. It doesn't require an oath to follow Michigan or support Michigan law or the Michigan Constitution, does it?
It does not.
Should that trouble us?
No, and I think there are 5 sort of essential elements in this Friedland test that's sort of adopted in Cotu and really governs, I think, much of the analysis here.
How do you get past the first element?
Pardon?
How do you get past the first element? It must be created by the Constitution or by the legislature or created by, and when it says created, it means a position, right? For a position to be considered a public office. I mean, I think, you gave your opening preamble there. I certainly agree with you that we should hold people accountable who break the law, whether they're law enforcement officers or not. I agree with that as a general principle, but here we're trying to hold them accountable in a very specific way, or I guess under a common law crime, the parameters of which are not very clear. My general understanding is that that crime typically would apply to people who are appointed or elected to public office, to high-level public officers. That's traditionally how it's been applied. And when it's been applied to lower-level officers, it's only been done where there's a very specific reference to those officers, either in a legislative enactment to the position or in a charter provision, for example. So I start from the standpoint that you're asking us basically to look at the outer bounds of this crime and push it down to a lower level officer. And I'm looking for, and I understand we have this statute, 764.15D, that gives them the authority to enforce the law, but I'm trying to understand how their position was created, either by the legislature or by a local charter or by something. Is there some law that authorizes the Michigan State Police to create these task forces?
Specifically to create these task forces, I'm not sure if that's explicit anywhere. But again, I think Section 15D really is the crux of this. And you talked about creating a position. And I think this does create a position.
And maybe not all of us agree, and maybe you don't agree, but that's how I read the test that you're referring me to, right? It says 5 elements that are indispensable for a position to be a public office. Then it says it must be created. That means the position must be created, right? So is your position that the 764.15D creates the position of member of Drug Enforcement Task Force?
Well, yes, Your Honor. And I think
multi-jurisdictional task force?
It does. And I think to focus on the title or the lack thereof of a specific, category is contrary to Friedland. Friedland made very clear that it's not the individual's title that really matters here. It's what they can do. It's what the legislature has authorized them to do. And there's been a very clear authorization here to act as state or local officer. And you can go to the code governing Michigan State Police and see all the things that Michigan State Police and therefore these individuals can and may do. And so I think COTU is important here, not just because this has to be applied, but because it held that law enforcement officers have traditionally been considered public officers. And the fact that these are also Border Patrol agents, I think is...
Let's talk about COTU for a minute. I'll try to find my copy of the opinion. Because it looks to the 4th element of your test that you're referring us to. And it says that, let's see if I can find it here. The 4th element is satisfied for a very specific reason and one that's not present in our case. And that's because there's a statute that creates the position of deputy sheriff and talks about what their duties are, right?
Yeah, I think, well, yes, there is a very specific provision regarding deputy sheriffs and their appointment.
It says, regarding the 4th element, we recognize that deputy sheriffs do not perform their duties independently or without the control of a superior power other than law. However, this element also encompasses inferior or subordinate offices authorized by the legislature that have been placed under the control of such a superior office. Because the legislature has authorized the appointment of deputy sheriffs, an inferior or subordinate office to that of sheriff, we conclude this element is satisfied. See MCL 51.70. We don't have a counterpart to MCL 51.70 in this case, do we?
We don't have an explicit counterpart that creates the position of deputy sheriff to be appointed by the sheriff. But what we do have is in 15D again, that where an officer is participating in a task force with a state or local law enforcement agency and is being essentially directed by that, they're acting under the authority of that state agency here, the Michigan State Police. Their duties are prescribed by statute, by 15D generally, and subsection 1, and the immunities are in subsection 2. But the specific
There's no,
conduct
when you say duty, there's no duty in this statute, is there? The Border Patrol agent or any federal officer doesn't have a duty to be on a task force or to undertake these activities. That's entirely voluntary, is it not?
I wouldn't say it's voluntary, and I think if you look at MCL 28.6, which is where the authorization for Michigan State Police comes, what they can and can't do, it's not framed as a duty in any of these statutes that authorizes law enforcement actors to act. It says they may seek search warrants, they may make arrests on the states and highways or whatever. They don't have a duty to do so. The duty is more general, protect the peace. These act as peace officers, which these individuals have, one of them admitted that he was. And now this gets into sort of a semantic peace officer compared to police officer. But I don't think that those distinctions really matter. Let
me ask you this. Is it your position then that any lower level individual, government-employed individual, who has an authorization by statute to undertake some act, then would be considered a public officer
No.
for purposes of a misconduct in office charge?
No, because that's sort of borne out in the second element of the Code 2 test, where it talks about a delegation of the sovereign power of government. So in the sort of background, and Friedland talks about the importance of the duties, the heightened. There was I believe, an argument below about whether somebody who was appointed. No, excuse me. It was in an 1879 decision by Justice Cooley that talked about if someone is appointed as a janitor to work in a state building, that's not a public officer, and we sort of all know that implicitly, but it's because the duties that they're assigned are delegated by the legislature are, I'd say, less important, but they're not delegations of the sovereign power of government. So here, these are acting as law enforcement officers to the same extent as state or local officers, and through Code 2, which recognized that law enforcement officers generally, and specifically deputy sheriffs, local police officers, historically have been considered public officials for purposes of this crime or very related circumstances.
So, Mr. Allen, is it your view then that any state police officer would be a public official for purposes of this analysis?
Yes, unless there was some sort of accepting, they were a short-term employee or something like that. But as a general matter, yes.
But not necessarily the janitor who works in the state police substation.
Correct.
That's sort of the line?
The lines might be blurry, but I think it's very clear that this court has consistently held that police officers are law enforcement officials. And it's because of the things that they're, I'm sorry.
In certain contexts, right? Not in all contexts. It's not
Well,
broad holding that they're always, no matter what action they're undertaking, right?
No, that's true. The crime would only apply where they're acting under the color of state, acting in the course of their duties. So there's a case, Milton, I believe, where the law enforcement officer was having a sexual relationship with an underage girl in his squad car while on duty. But nonetheless, because he wasn't using his authority of a state law, that may have been a Court of Appeals decision, I'm sorry, but because the officer was not acting under his duties as a law enforcement officer, that didn't qualify for misconduct in office. There was no question he was a public officer at that time and really for all times. But the other elements, whether this person could be charged and convicted with the crime, goes to whether the conduct at issue was carried out under the color of their duties with misfeasance or malfeasance and with a corrupt intent. So it's not that any time an officer acts on duty, off duty, is automatically committing misconduct in office if it's a...
Are all the attorneys in your office public officers for purposes of this crime?
I haven't really run the analysis. I would think yes. I'd like to reserve any admission.
I was going to come up with a hypothetical involving
Sure.
Mr. Restuccia, but I didn't want to put you quite
Please.
directly on the spot.
That's all right.
Okay, well, I think it's an interesting question. To me, this is pushing the outer limits of what this crime encompasses. And I think that the rules are in place to try to give people notification, an idea that they may or may not be covered by the crime. The idea that you don't know if you're covered by this crime or not tells me a lot, because in our law, the way our criminal law is supposed to work, people are supposed to know what laws apply to them and what laws don't. So this law is obviously not very clear.
I think as a general matter, the common law crimes are not quite as clear as statutory crimes. I mean, they've developed over time, and
But I think that's why we have this test, so to help us try to determine when people are pushing the outer limits of who's covered by the crime, to determine. And that's why I think we have to look at the test and really take a close look at it and make sure that all of the elements are met before we just open it up to a whole new category of people. Having said that, I again agree with you that I think public or law enforcement officers and everyone else should be held accountable when they break the law. Whether we do it this way or not, or the legislature has to do it another way, I guess is what this case is all about.
Well, everybody's responsible for breaking the law. It's a question of whether they're responsible for, whether they've broken the law in the context of their public official duties, right? So,
Correct.
Mr. Allen, I'm afraid you probably are on the hook if you break the law in the context of your duties as an attorney general, right?
That's
But if
fine.
you go home at night and break the law on your own time, you're still accountable. But
Correct.
maybe not for this.
But not for this
common law
5-year felony.
crime. I don't know.
I think that's accurate, and I think to the extent there's any hesitation about someone, a federal law enforcement officer being ensnared in this new crime that they didn't know existed or applied to them, this is a difficult crime to commit. There's, as I said earlier, you have to commit
Just so we're clear, I'm not sympathetic to the defendant in this case. I'm trying to make that evident. But I'm also, my job is a little bit different than that. It's to determine whether this crime applies to this individual who's in this sort of vague category. And it's sort of striking to me that I can't even find a statute that gives the state police the authority to create this task force. And they apparently have lots of task forces, and I'm sort of glad they do, for lots of different reasons. But I'm not really sure why we don't have a little more of a regulatory backdrop for that to weigh this question against.
As far as the existence of task forces, I think really those are just groups of law enforcement officers acting together. There's nothing more or less, as far as I know, that they can do with their law enforcement authority. They're just acting together for a particular purpose, perhaps on an ongoing basis, I think, as in this case. They have a particular reason for working together, maybe with state or local officials who may have different levels of intelligence or history with a particular area.
Let me ask you this. These task forces are funded by federal grants primarily, is that right?
I'm not sure about that. There was nothing in the record about that. I think sometimes there is federal monies being used. I don't think it's a necessary component.
If it's true that the federal government funds these task forces and therefore incentivizes the local law enforcement officials to put them together and to include federal agents, how should that influence my thinking about this case?
I think there are a lot of people who we would all agree are public officers who are acting in offices where federal funding comes into play, whether it's the head of a statewide agency that is using federal funds to carry out its duties. I don't want to get too specific because I don't want to misspeak, but a state-level cabinet official, what I assume would be a public officer. And I would imagine for most state-level cabinet positions, there's federal monies coming in to carry out environmental protection or what have you. And I don't think that reduces the fact that there's federal monies involved for a state law purpose reduces at all the likelihood that that individual is a public officer.
I apologize for monopolizing your time, but one last question. Can you give me an example, either in Michigan or any other state that has this common law crime, of a lower level official qualifying for the crime whose position was not created in a charter or by statute, or is there any example of?
I guess I would quibble a little bit with the premise that, and maybe that's just a disagreement we're having, that this does create a position. It does not create a title for this individual, but it authorizes.
What part of the
an
statute
actor.
are you referring me to that creates a position?
Well, again, it's I don't want to say it's implicit, because I don't think implicit's the right word, but the creation of an office, a public office, under Friedland and really under Cotu is looking to what that person is delegated to do by the legislature. And here, the full panoply of state or local law enforcement duties, as well as the privileges and immunities, are all applied to these individuals. And that sort of group, that bundle of rights and responsibilities is what creates the office. The legislature didn't have to say, this creates the office of state authorized officer. For this that would really be elevating the form over the substance. The legislature saw fit to authorize certain officers to enforce our laws.
You're
and
down
by
to
doing
1 minute,
so,
Mr. Allen, I'm just letting you know.
Unless there are any other questions, I'd like to reserve the last minute of my time.
You're 52 seconds.
My last 50 seconds.
Yep.
Thank you.
Good morning, Your Honors. May it please the Court. Rosemary Gordon Panuco, and don't worry if you can't pronounce it, nobody can. appearing on behalf of Mr. Nicholson and Mr. Bruce. We're appellees in this particular matter, and I've been sitting here wanting to answer Justice Viviano's question. And I think perhaps we need to talk about the statute that I found. I actually was looking at 15D, 764-15D, and I said, boy, this is part of a whole bunch of arrest statutes, Chapter 4 of the Criminal Code. And so I started rummaging around in there, and I came across 764.15, which specifically deals with an officer in the United States Customs Service or the Immigration and Naturalization Service without a warrant may arrest a person if all of the following circumstances exist. And one of the things that has to be there is what's really missing, starkly missing in this case is...
What was that statute that you referenced?
I'm sorry, this is 764.15. It's in the same section, it's just up a couple.
Right, got it.
In that. And one of the requirements for them to have that power is that an officer has received training in the laws of this state equivalent to the training provided for an officer of a local police agency under the Commission on Law Enforcement Standards Act. That's not the case here, and that's pretty apparent from the record that none of them had any training in the Michigan law with regard to this. Border Patrol is kind of an outlier with regard to federal enforcement. It is now under the Department of Homeland Security. And what's interesting is, as I was reviewing this case, I got to thinking, well, why do we have, what law enforcement in a sense, or what police powers? Border Patrol is dedicated to the border. If you want a criminal investigation, that's ICE. Because why did they create ICE if Border Patrol could do criminal investigations, and they don't? So that was just sort of my thinking with this. So I think going back to the question that you had about was this created, I don't think 15D creates this position any more than 764.15 does. It tells them when they can have the powers, but I think the specific statute applies with regard to whether they actually had the powers to arrest in this case, and they don't meet the test in that. There actually is a statute in response to your question on task forces, and that's MCL 28.6098, talking about, once again, that's Michigan Commission on Law Enforcement Standards Act, and that has several conditions for a task force. Once again, not met in this particular case, being that lists all the following requirements, and the first requirement is the law enforcement officer has met or exceeded minimum standards for certification under this act. And that the law officer is deputized by the sheriff. Again, it's all over the record. They were not deputized. They were not trained in the Michigan law. They don't meet those standards. And there has to be a written agreement that's filed with the commission. That's not the case. As a matter of fact, both I believe it was Furlong and Christensen, the two investigators from the Michigan State Police, specifically looked for a written agreement. There is none. That's in the record in this particular case. So the so-called task force here, which I find to be interesting when you add the motor carrier officers in there. Motor carrier officers, while they fall under the jurisdiction of the Michigan State Police, are not peace officers. And that's something that's been held. That is People versus Carrick. That's also Michigan State employees versus Attorney General. They're not considered that, and they're not considered that by statute. And their enforcement is very limited, much like Border Patrol. I talked about in my brief some of the cases that are out there. I even found some more, thanks to the largesse, shall we say, of the Pima County, the appellate bureau chief for Pima County, who told me about, yeah, I lost one of these cases because we had Border Patrol officers that pulled somebody over for what they thought was a DUI. Arizona says, no, you can't do that. Texas says, no, you can't do that. I found you can't stop them for not having Texas license plates. Once again, you're going back to that very narrow definition, which is defined by Congress. I believe that is Title 8, 1357, defines the duties of a Border Patrol officer, not 15D, 764.15D. And that's where you come back to that. Their position's created by the United States Congress. I think that you are going beyond any possible borders in Freeland to hold that Michigan State police officers are, that Border Patrol officers are public officers for this particular crime. Because once again, they talk about the position being created by the Michigan
Counsel,
legislature.
what would they be covered under then? Help me to understand then, like, what would they be covered under?
What would they be covered under? The general
Right.
criminal statutes. They were charged with larceny in a building. Now, the jury happened to find them not guilty of that. But like many of the other cases with public misconduct in public office, I believe even in Cotu was one of them, the case that came along with that case, I think it was Carlin, and there's been some others where you have some of these police officers, they're also charged with criminal offenses. So it's not that they're not going to be held accountable, it's just that this particular crime doesn't fit.
Under what authority did they have to even be on the premises then, in the first place, in order to be afforded the opportunity to remove property improperly, at least that being the theory? If they didn't have the authority as Border Patrol agents, they're not motor carrier officers, they're not, we have a lot of what they're not. How are they even able to be on the property, to be in a position to do what they did, allegedly?
Pretty much as a private citizen. And that's Border Patrol, or I'm sorry, not Border Patrol, motor carriers, it's not within their authority to be out there executing search warrants.
And
They were invited along by JNet.
A private citizen would have a right to be on somebody else's property uninvited to remove property from them?
If the police officer requested assistance, and that's what appears to be the case here.
So the
is-
police officer granted them that authority to be there? The Michigan State Police, the Joint Task Force?
Yes, ask them to come help out.
So that authority, though, does not affect whether or not they're responsible for?
No. If you look at what actually happened in this case, these guys were basically, and using this term, rent-a-mules to drag, they didn't pick out the property to take. They were told what property to take by the Michigan State Police. They were nothing more than moving men. If they brought in a moving company and said, here, I want you to pack up this, this, and this, and put it in our trailer, that's exactly the role that these gentlemen had.
Would it be your position that a private citizen could perform that task in relationship with the Michigan State Police?
If they requested their assistance, yes.
Would there be any qualifications necessary for a private citizen to do it?
No.
The
But that
Michigan
doesn't
State
make
Police
them a
can
public
deputize,
official.
they can deputize any individual person to make arrests and execute warrants?
No, that's not what happened here, and that was.
Well, that's what Justice Bernstein just asked you.
Oh, that to make arrests? No, they could make citizens arrests.
But they can deputize them to come and assist them in removing property. If that is the case, then what is the point of the statute, 15D, which specifies when a federal law enforcement officer acting in this context has all the privileges and immunities under Michigan law?
Well, in that particular case, you have to talk about the two things here. One of them is assisting law enforcement. And I think that you're talking about a federal law enforcement officer, and I think they probably had in mind DEA and FBI. with
But
regard to
they
that.
would have said that. It says a federal law enforcement officer. Are you saying that a Border Patrol officer is not a federal law enforcement officer?
They run right on the line on that. I think technically, if you define law enforcement officer very broadly, the answer to that is yes. But if you look specifically at what they're tasked to do and how the other federal agencies and the constraints on their arrest power, other federal agencies don't necessarily, they can't arrest for any
The
federal
statute goes on
crime.
and defines what's necessary. Authorized to arrest under federal law, they were. Authorized to carry a firearm under federal law, they were. And then one or more of the following, and that's where we get down to, all of this,
The
whether they-
assistant.
the following creates a position.
But it doesn't create, my
Well,
argument is
that's
it
the
doesn't create a
case.
position.
That's the case, not citizen's arrest or any of the rest of that, isn't it? Isn't that what the case is about?
The case is about whether this creates a position, and I say it doesn't. It allows authority, but it doesn't create the position of a U.S. Border Patrol agent. That's something that Congress did. And I think for the very specific crime, common law crime of public officer, misconduct in public office, that taking this arrest authorization statute and saying that that turns them into a public officer
This is much
creates a
more than an
position.
arrest authorization.
The
Federal law
subsection you
enforcement.
referred to, 764.15 sub 2, is when they can make an arrest on their own what the possibilities are.
When they're on
This-
duty.
The specific statute that applies here, I think what Justice Zara is asking about is it's more specific and actually governs what was going on in this case.
May enforce state law to the same extent as a state or local officer.
Then I still have a problem with the fact that you are not, once again, it's not creating that particular position.
Well, the statute is creating something. Most statutes create something, but for this statute, there would be no federal law enforcement officers with the authority to do what they did in this case. It's only because of this statute that we effectively created the position of a federal law enforcement officer with the authority to participate in these kinds of joint investigations. Isn't it really that straightforward?
Well, I don't think it is, and I think that that is not what the Friedland test compels in this particular case. I think secondarily to that particular thing is that you get going back to the Friedland test, the duties here are not performed independently. They were specifically had
So
to be
what?
directed.
What's
They
the
had to
rele-
be supervised by the
What's
Michigan
the
State
relevance
Police.
that they were or were not created? They were working independently of each other. How does that vitiate the idea that they were carrying out law enforcement authority of the state, sovereign authority of the state, and they were doing that pursuant to a statute, and but for that statute, they couldn't have done that.
I still don't think that meets the Friedland test, and I'm coming back to their duties must be performed independently and without the control of the superior power. And again, the record is replete with references to the fact that they couldn't stop someone. The Michigan State Trooper had to do that. They can aid them. They didn't do the search warrant. They didn't make entry in this particular place. They were perimeter security. They were there only to assist in the sense, yes, they can assist under this statute, but they are not performing their duties independently. They are acting at the direction of the Michigan State Police. Again, I think this takes them out of, they are not the public officer that the common law crime was intended to
I don't understand
police.
your focus upon their allegedly limited authority only to assist when 764.15D says a federal law enforcement officer may enforce state law to the same extent as a state or local officer, assuming that certain other conditions are satisfied.
Well, I think that's where I disagree on my interpretation of Friedland being that the position needs to be created by the Michigan legislature, and I don't see an arrest statute as creating that position. It gives authority, but it doesn't create the position. And it also, while it says they have that duty, they also, again, read consistently with 764.15, that's consistent with the testimony, which is they had to have Michigan State Police presence in order to do something. They weren't authorized to do anything beyond that without the Michigan State Police being there, and they are the ones that are controlling things. And again, that goes under in the Friedland test, where they're not performing their duties
I
independently.
don't think that's true, even if that was relevant. I mean, in these kinds of joint task forces, there's no requirement that every time you have a state law enforcement officer or federal law enforcement officer, there has to be some accompanying state law enforcement officer. I don't know where you get that from.
I'm going to, let's see, 13 years in the Wayne County Prosecutor's Office, actually.
And that's been your assessment?
That's been my experience, and that was actually the testimony in this particular case, is that that's why you always had to get state law enforcement there if the feds were going to do a search warrant. That's why you have to get state law enforcement there they always involved them in any of the task forces I was involved with that had state and federal mix. They always had the state guys there, so they had the state authority.
Of course, it's a joint task force, but again, that doesn't mean that every time you have somebody coming from one component of that joint task force, there has to be an accompanying member from somebody from the other sovereign.
Well, again, I'm coming back, I disagree with that, but that's, once again, and even Border Patrol amongst themselves, it's not, basically, and you had that from Agent Migliori on there, that they can't just go off on their own and do things unless it has an immigration purpose. And they are a very, very narrow class of federal law enforcement officer
So ATF has limited federal law enforcement authority.
They have a
And
much
the Secret
broader.
Service has limited law enforcement authority. And the ICE has limited law enforcement authority. They all have limited law enforcement authority, don't they?
ICE's command is broader, FBI command is broader, and DEA, ATF, again, a broader category. Border Patrol, it has to be tied to immigration. It has to be tied to their very specific mission.
Are you taking the position that if instead of Border Patrol agents, these were FBI agents, they'd be properly charged?
I think you'd have a much better argument that they had the kind of broad authority that would make them police officers contemplated by what I believe what 15D contemplates.
I don't
Well, you
see
keep
where
going to
freedom-
15D, but this case, or I'm sorry, it is 15D, but I don't understand how you draw this distinction. The question here, under this statute, is really, are they Border Patrol agents, or are they agents of the hometown security team? And if it's the latter, then it's a position that falls within the statute. And if it's that they are Border Patrol agents, that was created by federal law, not the state constitution or legislature, and then you would prevail. Isn't it just that simple? Isn't that the question we have to resolve here?
You cut right to the chase. Yes, they're Border Patrol agents. Again, note their mission with this particular
Are they not
task force
are they not
was,
also members of the hometown security team that was created?
they participated in it in a temporary basis. That's something that's in the record. And they were there to gather intelligence. It's an interdiction team with motor carrier, and which I think suggests the very limited nature of what hometown security is because of their limited scope of authority.
Is their assignment, is it for any particular term or duration?
That's not in the record, but I know that Mr. Nicholson had only recently been transferred in there, and that there was another agent that was not there and present. So it sounds like, again,
Is there
from what I
anything in
could
the
gather from the record, it was like a temporary assignment.
Is there anything in the record that shows how this task force was administered? Who was in charge? What the lines of authority were? And
Sergeant Temelko was the Michigan State Police, I believe it's a sergeant, technically in charge of it. However, what's in the record is that the Border Patrol agents reported back to their bosses in Detroit. In fact, that's where they went back to after this. That's the Border Patrol station that they were responsible for reporting back to with regard to the intelligence that they gathered and the things that they were doing. So they were constantly reporting back. That's basically what was in the record here between Border Patrol agent Migliori and Nicholson, who testified. That was what.
how do they know when they go out to the scene to execute a search warrant, who's giving the orders and who's taking them?
JNET, the Jackson Narcotics Enforcement Team, I think that's what it is, and that's the Michigan State Police. It
maybe
was
the
their
Jackson
search
County
warrant,
Sheriff,
their
or maybe
operation,
local
their
law enforcement?
investigation.
But so that means somebody from the Michigan State Police is in charge of the task force?
Yes, I believe that was Lieutenant Cook, and
how do they-
officer in
how do
charge
they-
was Lewis, was Jackson County Sheriff's.
How do people know this? Is it like word of mouth? Is it oral tradition? Or is there some regulation?
With regard to JNET, or who's in charge?
Who's in charge of this task force, this hometown security team? How's it run? Who's the boss? Who's the lower officers? Who knows who they have to listen to? Or does everybody just show up and start giving orders to each other? How does it work?
That's not in the record, and with no written document that was able to be unearthed. And I think that's why they require a written document that sets forth the who's in charge and the demarcations of it and the duty. And that's what's missing in this case, is a written agreement.
Do you object that they were permitted to execute warrants?
Yes.
They were not permitted to do that, so they
Well,
they
I
were-
think
everything they did was not lawful.
I think that they went along and helped. I think it was a matter of team comedy.
So it was sort of it was just, they were being kind of good, helpful citizens,
Yes.
but you don't think 15D gave them some portion of the sovereign functions of government to be exercised for the benefit of the public?
I think you certainly can make that argument. I disagree with it.
That's the argument they've made.
Well, I know that. I'm disagreeing that it creates their position under the Friedland test, and that.
It never says we need the magic word position. It says a public office is created when, for a given period, an individual is invested with some portion of the sovereign functions of government. And they were here, right?
That's only one of the 5 elements, and I think the other elements are not satisfied.
Okay.
That's the problem I have with that. Your answer to that is yes, but it's not.
Yes, but, okay, thank you very much.
Thank you very much.
Thank you. I hope you can speak as quickly as Mr. Restuccia.
Wish I could, but I just have one quick point. Justice Zara, you were talking about what federal law enforcement officer means. Does this include FBI? Would that change the calculus? But federal law enforcement officer, for purposes of this statute, is defined by statute in 761.1E, and it's quite broad. It says it means an officer or agent employed by a law enforcement agency of the United States government, and they are enforcing laws of the United States. It doesn't say all laws, most laws. These are federal law enforcement officers and by statute.
Do you have a response to my question about whether there's some document somewhere, even some regulation or some order or something telling us how this task force is administered, or is the only authority for the task force the website, the services guide that references it? Is that?
Well, I don't think the website provides any legal authority, Your Honor, but there was a clear understanding that the Border Patrol agents would be serving under the MSP direction and control.
Is that generally how it's done when these task forces are enforcing state law, that the state law officers would be the lead, and presumably if they were enforcing federal law, the federal law enforcement agencies would be the lead? Is that typically how it's done?
Yes, Your Honor.
Counsel, just very quick, what's your jurisprudential concern about this case?
My jurisprudential, I'm
The
sorry.
jurisprudential concern on a global perspective, why is this of concern to the Attorney General's office?
Well, it's of concern because I think that individuals who are entrusted to enforce our state laws should be held to the same standard as all of the other officers who enforce our state law.
Thank you, counsel. The
Thank
case will
you.
be submitted.